just after 10 a.m. on Wednesday, August 12th, 2026. Thank you all for coming to our regular Board of Directors meeting of the Harris-Galveston Subsidence District. I'll note that we do have a quorum, and if you would please join me in the pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I understand that we do need to administer the oath of office to a couple of reappointees in the city of Houston. Madam Prescott, if you would do the honor.
Mr. Canonico, Ms. Anderson, and then Mr. Long, Galveston County Official.
Good morning. I'm gonna read the oath. I ask for you to, after I state I, please state your name and then repeat after me. In the name and by the authority of the state of Texas, I do solemnly swear that I will faithfully execute the duties of the office of Harris-Galveston Subsidence District Board of Directors of the state of Texas, and will to the best of my ability preserve, protect, and defend the Constitution and laws of the United States and of this state, so help me God. Thank you. We sign your oath and we'll pick it up later.
Well, congratulations, everybody. Being reappointed, and welcome back. That takes us to item 3 on our agenda, to accept comments from members of the public. Members of the public are invited to comment on any of the items on our agenda, as well as any other item pertinent to the society that they would like to talk to us about. So this is that opportunity. I only have one person signed up, Ms. Rowell, you're up.
Oh, right here.
Good morning, Chairman Petroff, board members, and Mr. Turco. My name is Melissa Rowell. There's an old story attributed to Davy Crockett from his time in Congress. Congress had voted to spend $20,000 to help people who had suffered a devastating fire. Later, a constituent challenged Crockett over that vote. His point was simple. You are free to give your own money away, but when you are dealing with the people's money, you have a different responsibility. I think that principle applies not only to how government spends money, but also to how government takes money. The Harris-Galveston Subsidence District describes its business fee as an economic incentive intended to change behavior and reduce groundwater use. I understand the need for rules, permits, limits, and consequences when those limits are exceeded. But there also has to be proportionality and fairness. In the Woodloch matter, we are talking about an exceedance of approximately 2 million gallons that resulted in an assessment of roughly $107,000. But I think we also need to look at the bigger picture. Over the long term, Woodloch has reportedly pumped approximately 30 million gallons less groundwater than it was permitted to pump since 2003. 30 million gallons left in the ground. Shouldn't that conservation record count for something when we evaluate a 2 million gallon exceedance? For perspective, the city of Houston reported losing about 31 billion gallons in 2023, roughly 87 million a day. Compliance should not be viewed through a keyhole. If the purpose of these rules is ultimately to reduce groundwater pumping, then the overall record of groundwater use ought to matter too. When someone can conserve tens of millions of gallons over time, yet face a 6-figure charge over one period of exceedance, I think this board should stop and ask whether the fee is still functioning as an incentive or whether it has crossed over into punishment. We often say government should spend money as carefully as if it were our own. I would go further. Public officials should be even more careful with public money than they would be with their own, because it's not their money. It has been entrusted to them. And I believe the same principle should apply when government takes money from people. A fee may be authorized by a rule. That does not relieve us of the responsibility to ask whether the result is reasonable, proportional, and just. Behind every permit number is a person, a business, a nonprofit, a utility, or a community that ultimately has to pay that bill. This matter has been disputed for well over a year, and the person involved has apparently reached the point where he is simply tired of fighting it. Maybe the rules allow this result, but I hope this board will ask a deeper question. Is this really what we intended our regulatory system to do? An effective regulatory system should encourage compliance and conservation. It should not leave reasonable people feeling financially beaten into submission. So as you consider fees, penalties, settlements, and enforcement decisions, I ask you to remember both sides of the Davy Crockett principle. Be careful when you spend the people's money, and be just as careful when you take it from them. Thank you.
Thank you. Appreciate your comment.
Thank you.
I don't have anybody else signed up. Mr. Davis, I see you're there.
I was mentioned in this. May I speak just briefly?
Absolutely.
Okay, good. I had something here. Thank you. Just very briefly, there has
For the
been,
record, would you state your name?
yeah, Brad Davis, Woodloch. There's been a lot of confusion about pumpage, and so I just wanted to provide to the board some numbers here. When I first got that letter of that fine, I thought there must be something wrong here, it can't be that. And so I called, I talked to Dylan, and he said, either come to the board or pay the money, it's the only option. And so in preparation to come here, I asked him, can you give me my amount of pumpage every year? So he did, and I have my handwritten notes here, so today I'll share them with you, and I also printed them because my handwriting's not very good. And the thing that is, it'll show you that I've averaged probably 8 million over 20-some years that I've had this permit. When we started trying to get information on our well pumpage, we got more information from the district, and I have those here, and the numbers, the discrepancies are so much different. You know, one says 3.8 million, this one's amazing to me. It says that we pumped 14.3 million from the well pumpage, but the total pumpage was 21.7 in 1 year, which I only have one meter. There's no way that it can be separated, but on the 2023, when we talked, it was 9 million, 9.1 to be exact, and then I've got records here saying it was 21, and this is consistent with all these records that we received. 2021, it says we pumped 3.8, but over here it says 7.7. So there's a lot of confusion here, and like she said, I just want out of here. I just want this to be over. I never intended for all of this to go on. And we try our very best to be good to our residents, to play by the rules and do everything else. So that's all I had. I just want to share with you this. I made copies. I was actually going to come up later and say this, but if I may I give this to somebody?
You can just give it to Veronica and she can pass
Okay,
out.
and if anybody else wants a copy, I'm happy to share their copy. Thank you very much.
Thank you, appreciate your information.
You want copies?
All right, and I have no other signed up, but if anybody else is in the audience and would like to speak, this is the opportunity to do so. All right, thank you. We'll move on to our item 4 on our agenda. We can make copies for everybody. Item 4, approval of our minutes of our regular board of directors meeting that was held
Motion approved.
Second.
We have a motion and a second. Is there any discussion on those minutes needed?
Can I say no, wasn't at the last meeting?
Sure.
And me too.
And me as well.
First, just a motion, second, I'm sorry.
I was
first.
Motion.
So if we take all those abstentions, do we have a majority? Okay, we're still good. All right. So any discussion specifically on the minutes needed? Hearing none, I'll call for the vote with the abstentions noted. All in favor, say aye. Aye. Any opposed? Motion carries. Item 5 on our agenda is to receive the hearing examiner's report and consider granting, denying, or amending applications for water well permits heard in July 2026 and prior. And this will be, except for, not including, I suppose, item 5.1, which is the Woodloch matter.
Good morning, board. The report for the recommendations for those persons who have made applications for permits for water wells or the request for cancellations, modifications to current permits has been published, however, for the July 7, 2026 public hearing and a couple before then. However, there were a couple that was not included in the report, and I'll bring those to your attention at this point. First, there's HGSD, and I'm gonna spell that, CHISPAS. HGSD has lead well 9049, it's regulatory area number 3. They currently have a permit for the term September 2026 to August 31st, 2027. And so this is a renewal, and renewal is for 100,000 gallons. The permittee was not present at the hearing. The recommendation is that the board renew the permit for the 100,000 gallons that's been requested. On the permit, we have the regulatory provisions concerning conversion because they are in regulatory area number 3, which would be 80/20. On the current permit, the district has included a requirement that on or before February 1st, 2027, the permittee shall furnish the district with a report of feasibility and groundwater reduction alternatives and describe in detail future plans for reducing its usage of groundwater so that no more than 20% of the total demand comes from the permittee's water well. The report shall also include a projected timetable for conversion. Provisions are not intended to prohibit the permittee from consenting as part of the groundwater reduction plan, a well-documented case that alternative water is not attainable as a result of any of the following. It talks about the economic impact and no adequate available substitute. This well, however, is in Harris County Mud 48. It serves that area, so we believe that there is an alternative water source available. Therefore, this permit will not only include those provisions concerning the regulatory areas and the requirement feasibility report. They did not provide the feasibility report. It will also include the provision that says the permittee shall reduce the use of groundwater so that no more than 20% of its total demand comes from the permittee's water well by September 1, 2027. So the recommendation is that the board issue permit, however, with these provisions, and that the allocation is the same as that which was previously permitted. Any questions concerning permit 9049?
Do we have any questions on that?
And then we have well number 12174, Douglas and Sherilyn Ledge. This is also a regulatory area 3, currently permitted for 100,000 gallons. Permit serves a house, a mobile home, and a pool. The allocation is the same amount granted for, or requested and granted in the previous term, which ends August 31st, 2027. The recommendations of the board renew the permit for 100,000 gallons for the 12-month period. That's
questions about that permit? I don't think so.
Okay, well then we make recommendations as they are in the report, and at this time, ask if there are any questions concerning any of the recommendations of this report.
Any discussion concerning the report? Or do we have a motion?
So moved for approval.
Second. We have a motion and a second. Does anybody need to abstain from any of the permits?
I have a few that are members of the organization I lead, so in an abundance of caution, I'll abstain from Galveston Bay Foundation, Gulf Coast Authority, the City of Woodloch, the City of League City, and the City of Texas City, and I've emailed those to Elizabeth, so she'll have it for the minutes.
Great. Anyone else? All right. Any additional discussion, questions regarding any of the report? Then I'll call for the vote. All in favor of approving the recommendations in the report, as presented, with the abstentions noted, please say aye.
Aye.
Any opposed? Motion carries.
Thank you.
So that takes us to 5.1, which is to consider the hearing examiner proposal concerning the application by Woodloch Mobile Home Park. So, how do we want to take this one?
Great.
Last month, you might recall, the board of directors continued this matter to this meeting and asked Mr. Davis to sign an rescheduling order for a contested case hearing and hire local counsel or have the Florida attorney get pro hoc vice authority to practice in Texas. Those things did not happen. I did have a long conversation with Mr. Davis about this situation. He is eager to come to a settlement on it, and I think it's sincere. I want to make sure that everybody understands. Nobody thinks Mr. Davis is a bad actor. We're not talking about somebody who's a scofflaw or trying to defy the district. There was an error made here, and that we are applying these rules the same to him as we do to everybody else that has ever done this. And we can, I believe, reach a settlement. We can find a way to reach a settlement that involves V credits and other solutions, perhaps supplemental government programs or things like that. But at the same time, I believe that the board does not want to have this continued again and again and again. I think you'd like to see an end point to all of this. So my recommendation to you today is that you approve the final order as drafted, which denies the renewal of this application, but make that effective at some date in the future, probably after the October board meeting. That gives us 2 board meetings to reach a settlement with them, bring that settlement back to the board, have you approve the settlement, and rescind the final order and issue the permit. But if no action is taken, if we don't reach a solution, then that final order will take effect, and this permit will be denied. You'll then have 20 days after that to file a motion for the hearing in order to start the appeal process. So those are kind of the options. I think that we have an opportunity to get to a settlement, and delaying the effective date of this order will give us the time to work out that settlement. I'll be happy to answer any questions.
I'd like to make a couple observations. Based on the last hearing, the information that was provided to the board, it appears that this has nothing to do with the year of COVID. Our policy at the district has always been to work with everyone to try to get them into compliance. And that's what I see this process is, that's what I see that has happened up to this point, and I'm encouraged by your comments because that's consistent with district policy. To work with permittees, to bring them into compliance, consistent with the rules, and so I think that's what we ought to do. The last comment I want to make is the district, in my understanding, and I think I've been on since 2014, has never cut off anybody's water, has never threatened to cut off anybody's water, and nobody has threatened to cut off the water to Woodloch or its residents. And so I don't know if we need to take the remainder of this discussion up in executive session, but I am encouraged because that's what the district has always wanted, was to bring to this matter to resolution, and I want to support the efforts to do that.
So, if board members are ready to make a motion and vote, we can do that. Or if we feel like we need some discussion in executive session, I'm happy to, move this meeting into executive session for further discussion.
Well, it sounds like the main thing we need to try to figure out is the date to understand how this process goes forward consistent with district rules.
Right, yeah.
Did you have a recommendation on the date?
Anytime after the October board meeting, I'm sorry, I can't off the top of my head remember when that board meeting is gonna be. I think it's on the 11th or 12th, so October 15th would probably be a good day. Was it 14th? I guess a little time after the 14th. But yeah, sometime after that October board, anytime after that October board meeting, I think would be sufficient. I don't know that we're gonna go work things out in time for the September board meeting. I think we should be able to by the October, and I don't really want to think you want to see this drag on into.
October 30th is fine.
Would that give enough time for the, line item to be placed on the November agenda if we went the full 20 days after the October 14th board
Well,
meeting?
okay, but I'm hoping we have a settlement we can bring and put on the agenda for the October board meeting, which means our deadline for that is going to be at least 10 days before that meeting, so we know exactly what we're recommending, what the agenda item is going to say.
Well, you can always put the agenda item on the agenda and have it posted, you know, if there may be no action.
Well, that's true, that's true.
Yeah.
Well,
But we
I'd
can
rather
have
not
that.
I'd rather not post it unless we actually have something to be able to talk about, but I understand what you're saying. We can put it on the agenda and negotiate about it until that morning if we have to. But I'd rather not do that. I'd rather get it all settled and be on the same page as we come to the board. The 20 days is the deadline for filing a motion for the hearing. And, under the rules, without the motion including that delay in that deadline, adopting it today would give him 20 days from today to file the motion for the hearing. And so we don't want to start that process if we don't have to. That's the first step in filing an appeal. The first step is file a motion for a hearing. The board can either accept it and open the matter back up again, or they can reject it or wait long enough and rejects it is denied by operation of law, at which point he has a deadline by which he has to file a lawsuit and to appeal the decision. And that, we would then go forward with the lawsuit, have a district court judge
And we
make some of
don't,
these decisions.
we don't wanna trigger those if we're in discussions for settlement.
Exactly. So including the motion that we're delaying effectiveness of that and delaying the deadline for the motion for the hearing covers us for that contingency.
And so what's your recommendation for the date that the final order would become effective?
October 30th works, that way it gives us November time, and you have to work inside that.
October 30th?
Yeah.
That's
More
fine.
things numbers remember.
I'm fine with that.
Do we want to set a due date certain, or do you just want to use the 20-day language?
I think 20 days, that matches what the rules say, so I think it's clear what we did.
So, does anybody need any discussion on the order?
Doesn't look like it.
All right, well, I'll make the motion.
Excuse me, was that, may I speak on this matter?
No, sir.
I can't speak.
Your time for speaking is over.
So I'll move that the board approve the final order as presented with an effective date of October the 30th, and with the due date for a motion for rehearing 20 days after that date.
Second.
All right, we have a motion and a second. Any discussion needed? Then I'll call for the vote. All in favor of approving the motion as made, please say aye. Aye. Any opposed? Motion carried. Thank you. That takes us to item 6, comments reviewed by the general manager. We've had two approved in the last month. As the board knows, this is not really an action item per se, but it's an item for the board to ask questions about emergency items that came before the general manager in the last month. If necessary. Does anybody have any questions regarding these two items?
Yes, I note that the second application in area 3 states that there's no alternative water available, and yet the comment section says the property has a water line that fronts that property belonging to Harris County Mud 185, but they're not within their service area, and they require that they be annexed to provide service. Is that a condition of their permit that they petition to be annexed, or are we just not going to say anything about it?
Yeah, so we specified in that particular permit, and all permits like this, as not having alternative water available, because they would have to be petitioned, they would have to request annexation into that mud district, or in the mud district, so not in the service area, so, we've not asked folks to go to that, to annex me, so I can do that, that's something that we hadn't done.
Why not?
Well, it's just been our approach, because they would then become expand their taxing entity, the flood district would have to expand their area to that area, and we haven't asked anybody to go to that approach to get additional tax at that location when they're not inside the mud district. The location of the line is adjacent to their property, but it's just been our approach not to ask folks to be annexed into the mud district.
I would say for a mud district, they could serve out of district customers if the mud district chooses to. So it sounds like they're not willing to do out of district customers because they have the annexation process.
Understand the annexation.
So that's we're not about that.
Have they approached the mud to ask them if they can pay for their services?
Yeah, go ahead, Ron.
Yes, I did speak with representatives of the MUD, and I asked them if that would be a requirement in order for them to provide that property with service. And they recalled this property, and they said that yes, that is a condition of providing services, that land be annexed into the district.
Are they a taxing mud or just a
Yes.
service mud?
Yes, they must
Not really.
I'd be interested in having a discussion about that, actually.
We'll do it for Rules Committee.
I think Rules Committee would be where you have that discussion.
If we're requiring people to convert to surface water and the water available, but we're not requiring them to take advantage of the water available, what are we here for? That's all.
Does anybody have an estimated cost, what it would take to put this, entity on service water, hook up to the mud?
I doubt that's the issue. They don't want to be in the taxing authority of the money. I doubt it's the interconnect.
I think both parties have reasons that they wish to have certain things done a certain way, and they're not agreeing. So I don't think we can force that agreement to go do that. So they could go get water from somebody else too. They don't have to go to that mud district. But they're not in right now. They have to follow procedures on doing those things. It's tough, but I think Rules Committee can help. We need to encourage these behaviors.
We can do some, we can look at some of our information, see how many of these actually exist. I know that there are not that many, but, yeah.
It's not a lot of water, but it's still, that's our purpose, is to convert the surface water and get off our groundwater. And this is just, it's almost bureaucratic that we're not forcing them to do.
I'd just like to understand the issue. My libertarian background says that I'm ordering people to do
Yes. Oh, I think that's the question we're gonna get started.
Do you have a philosophical opinion?
Tell us to besides research, man. We'll take it in there.
I'll have to study.
Then turn over to the
I'm sorry I brought it up.
No, the
And that will take us to agenda item 7. General manager.
Is it possible to get the district website up on the screen for a moment? You'll have your general manager report. I do want to try to show you something here. It's kind of impromptu, so Veronica, I apologize for holding something. But if we just click on the recent news on our interactive subsidence map, and we just recently published the Instar map as an interactive map on our website. I'm going to scroll down and click on that just so everybody can see how that works. So you know, over the years we've used, and we continue to use, and will continue to use, our static GPS sites to monitor subsidence throughout the region. But over the last couple of years, we've been utilizing Instar, which is a satellite-based remote sensing of subsidence that allows us to get much more resolution and allows us to see between our static measuring points, which you can see up there as dots. And Veronica, if you could just grab that map and scroll it down so you can look at all of area 3. Same color scale, but you can scroll in there, you can zoom in and out and look at your areas of interest, but what you see there, those areas of dark red, areas above 2 centimeters per year. And that area extends along western Harris County through northern Harris County up into southern Montgomery County and into Grimes County. And we see similar areas over in Chambers County. This data set allows us to do a couple things. One, it allows us to show the impact of our regulatory plan over time, which is its primary purpose, but secondary, it's a reconnaissance tool. It allows us to see things between our static measuring sites so that we can then better inform future sites, inform future investigations, and it's available to the public out there on the landscape. And this is something that Ashley Bruder, who's our Director of Science and Research and Water Conservation, has led, and it's a great tool. And you and Casey have worked together to get this out there to the folks, and I really appreciate that effort, because I think since this has gone online, I've gotten a lot of positive comments on the information and how easy it is for the public to grasp where the real challenges are. So good job on that. And you'll see more products like this coming out in the future, I'm sure. But just one thing that was released earlier this year. And then earlier this month, or last month actually, right after the board meeting, we had an opportunity to go talk to folks with KPRC down at the Brownwood subdivision, and did a tour of the Baytown Nature Center. Talked more about subsidence down there, in the Baytown area in particular. They're working on a segment focused on subsidence in our region. It's anticipated to air in September. So we're going to be working with them to help get information out on the issue of subsidence and the work to be done by the Subsidence District to prevent that. Online registration for the 2026 Gulf Coast Water Conservation Symposium has officially begun. Just a reminder, the symposium will be held on October 22nd, and it'll be at the High Regency Baytown. And then right at the end of the symposium, we're going to have a field trip to the Baytown Nature Center, where attendees can go and see a lot of the backstage stuff that you really don't get to see if you just go down there by yourself. But we'll work with the Baytown Nature Center. They got a great group there to go and show some really old relics of the lakes to Brownwood. So it's going to be a really good effort, really good event. I'm looking forward to having folks there. Otherwise, I think there's been a lot of work on the regional water planning side and GMA 14. GMA 14 met. They met earlier this year, and they have proposed DFCs. I included comments that we provided to them in their public hearing last night for your information. But basically, those comments were focused on the model that they're using for their DFCs, which has some issues just based on the analysis that we've done. And also just reminding them that even though they're pulling out subsidence as a metric in their desired future condition, subsidence is ongoing throughout GMA 14, throughout Montgomery County, in Grimes County, Brazoria County, Chambers County, and those things need to be recognized as part of those desired future conditions. Not that that's going to change their approach, but it's important for everybody to understand that we do a lot of models, and we use models to help inform our policy. All those models have assumptions. Those assumptions are based on what we think is going to happen down the road. But ultimately, the best gauge for what we do is the data that we measure every day. And that's ultimately what we hang our hat on, what we're working for, and that's why our regulatory plan does what it does. That's why we have tools like this incentive fee, to help incentivize compliance with the regulatory plan, because ultimately we're trying to turn that red and orange area up there on that map to the green that we've seen in areas of low conversion in areas 1 and 2. And that's the end goal for us, and, we're continuing down that path. With that, I'd be happy to answer any questions.
So, Mike, what are the white areas up there?
Yeah, so great question. And I'm going just the methodology for this, how this works is that the satellite spins around the Earth, and every so many days it throws a radar beam down, and then it figures out how long it takes for that beam to bounce back off of something that's reflected. And then it comes back in the same location in a given amount of time and does it again. And if there's not a reflector on the initial pass or the last pass, then we don't have correlation, so we don't produce any data there. So ultimately, in those areas, either we have decorrelation because of vegetation or some other type of issue, or we just don't have a reflector there that actually hit both in 2021 and in 2025.
So you need to go out there and stand with something?
We need to go up with reflectors every 9 meters throughout the area, and that would do it. And actually, there's some places where they actually have reflectors, and actually has a design that could be installed out there. But typically where there's water, typically where there's just open earth, it doesn't work real well there, but it does work really well when you have a reflector like a rooftop or road. And you can see, particularly we're in Fort Payne County, where there's still a lot of area to be developed, but you can also pick out some roads and some linear features that are associated with roads. And that's And those 2 big areas in the middle there, Parker and Annex Reservoir, Lake Houston up there in the corner. Most of that area in East Harris County is undeveloped, and northwestern Harris County is generally undeveloped. At least undeveloped in 2021, which is the first part of this comparison.
Any other questions of Mike? All right, thank you. So then that takes us to item 8 on our agenda, consultation with our general counsel.
Good morning again. Before I start off, I did want to point out, and I think what Mr. Davis wanted to come up and speak about again, is that he has already presented us with a planned groundwater conservation plan. In legal parlance, we would call this a supplemental environmental program. And this says that we're trying to conform with the rules from our GRPs that we do for other people, and it's certainly a step in the right direction. And we've already taken some positive steps toward reaching something. So Mike, I'll get a copy of this to you, or give a copy to Natasha, and we can start working on settlement.
Yeah, I think we understood from your comments that Mr. Davis was working with you, and we appreciate that very much. And we expect you to continue working with him.
Absolutely, absolutely. The goal has always been to treat everybody fairly. It's not fair to have some people paying disincentive fees and then having somebody else just over pump and not having them pay disincentive fees and letting them off the hook. That's not fair to the ones that pay the disincentive fees and encourages people just to pump and be honest. At the same time, we want to make sure that we're within the needs of the people that we're talking to, and we're actually taking a positive step forward for limiting groundwater withdrawals in order to stop the society. And I think this, in its 50-year history, this board has had a remarkable level of success. And the numbers, the subsidence numbers prove it out. The fact that we don't have 18 people filing lawsuits against us also proves it out. I think the numbers are probably too reasonable. But I think in this case we can reach a final agreement with everybody to live. On other litigation matters, I am going to present to Elizabeth something that she's going to put up on the agenda. It's going to list out where we stand on all of the current litigation, or portion of litigation that's going on, and the remarkable success there. I want to point out that in the last 12 years, you all have presented me with over 1,500 cases. Actually, you presented me with about 1,700 cases to be resolved. And we just crossed over the 1,500 resolved number. So we have either sent letters out, got them come in to get permits, we just settled with them. In some of the cases, we've had to go file lawsuits, which is brought to the table, got settlement. In a very few number of cases, we've had to go to the point of actually getting a judgment against somebody. We still have several outstanding judgments that we're working on. So it's, there are a lot of wells out there. We probably still haven't discovered all the wells that require permits. We're still finding some every single month. And along with the people that have permits and forget to renew it, or the ownership changes and somebody doesn't renew, or whatever happens. And all that leads to this enforcement program. And I just want to say it has been, I think, been very, very successful, and we're proud of our record. On the general litigation front, the 3 Cockrell cases are moving through the 8th Court of Appeals again. To remind you about what those 3 cases are, the first Cockrell case was, Cockrell is litigating over whether or not he should have been allowed to join in the contested case hearing when the hearing had been finished 7 years earlier, had been litigated through the appeal process, was sent back to the board for reconsideration, and he wanted to come join in the contested case hearing as a contestant at that point. The district rules don't allow that, they denied him that, he's now litigated, he should have been allowed in that case. The second Cockrell case is based on when the permit came up for renewal, he wanted to protest that, he wanted to contest the renewal of the permit. And because the law says those permit renewals are automatic, the general manager said, I have to renew it, it's already been renewed, we're going to ignore your request for contested case hearing because there's no way to contest a renewal. And that's the second case that's in front of the 8th Court of Appeals. The third case, which I believe is the only one that really has any merit in my personal legal opinion, they filed a declaratory judgment action against the district because that district issues a combined operating and export permit. Now, I have always said that those are meant to be 2 separate permits. They have different standards for how they get issued. They have different permit term lengths. For example, an export permit is good for 3 years unless you begin building the conveyance. Once you've begun building the conveyance, then it converts to a 30-year permit. And the Cockrells, because things are still being litigated, haven't begun building that conveyance yet. And it was part of the operating permit, so it came up for renewal. It was renewed as part of the operating permit for another 3 years. And what Cockrell's trying to say, get the courts to sell the district, is you can't do that. You can't have, the terms of the statute are very clear. It's 3 years or 30 years, or your permit expires. And so they're saying, no, it's part of the operating permit, which does get automatically renewed. So he's trying to get declaratory judgment, they can't do it that way. And that case, I really don't care about. None of my clients have combined permits, it's not anything we need to worry about. And it doesn't really impact anything we do here or how we operate with our permits. We don't do automatic renewals, we're not required to do automatic renewals. And so, and we don't have any export permits. I don't think we're ever going to have any export permits. But I think that's the case, that's why I'm gonna move forward. But the other 2 cases are problematic because if the court is opening the door to somebody, we call it lying behind the log, hiding, not doing anything while it moves through, while the permit application moves through the administrative process, and then at the last minute jumps in and tries to interfere, or waits until the permit's issued and then tries to appeal or attack that decision, that's very, very problematic. And where the Supreme Court had its oral argument, the question seemed to center around, if you are a party, you have to appeal, and you have certain deadlines by which you have to appeal. But if you're denied party status, you're not a party, why can't you just sue under the general provision that allows anybody who's dissatisfied with the decision to file a lawsuit? That's very concerning. I think that anybody who wants to attack a permit should have to have joined at the point to attack it as part of that contested case hearing. Because if you don't, then why bother with a contested case hearing? Just have the board vote on something and let the courts handle it. And that's not, I promise you, that's not a solution we want. So that's why I'm paying such close attention to these capital cases. I think they have a potential for disrupting what we do here. The other big controversies around the state, Kyle Bass has filed a federal lawsuit against the Natchez and Trinity Valley District and its board of directors, saying that they're caused taking his private property without compensation, that they violated his due process rights, they violated his equal protection rights. He filed applications. The board originally voted to declare them administratively complete to start the process for a contested case hearing. Two of those board members were later ruled by a court to have been ineligible to vote on that, and therefore that vote was invalid, so it was invalidated. That court also said, and I'm ordering the district to declare a moratorium on any new applications over a certain amount until you get your rules straightened out and figure out how you're going to deal with this. Mr. Bass didn't intervene in that lawsuit, so he wasn't present when they did. I wasn't part of that decision, and so part of this is suit over that moratorium and their decision to do a moratorium. Whether or not a moratorium can cause a taking is kind of an open question. A moratorium that lasts too long, which is one of those I know when I see it situations, definitely can result in a taking of private property. But I've got at least one case out of Dallas where a historic district was stopping all development within the historic district until they could get their rules written. They had meetings every quarter to work on the rules for 10 years and never got the rules adopted. And when the landowner sued and said, they're taking our property, they're just, and the judge said, no, they're showing due diligence for trying to get these rules adopted. 10 years isn't too long when they're meeting every quarter to try and get this done. In another case, the moratorium was put in place, and the landowner came in after 3 years and said, they're not doing anything. They said they're going to have a moratorium until they accomplish this goal, and they have done nothing to accomplish the goal. There were no meetings, nothing had ever been accomplished. And the court said, yeah, right, that's too long, that causes a taking, and we're in damages. So 10 years might not be too long, and 3 years might be too long. It just depends. And in this case, I think it's a little premature that the lawsuit was filed, but obviously something we're going to have to keep a very close eye on. There's another federal lawsuit that's moved to I think it's moved to the Fifth Circuit Court of Appeals now, from the Panhandle. That's from the North Plains District, where that landowner had exceeded his permit limit several years in a row. The district was going to take enforcement action against him. And they did not, but they refused to renew his permit because of the violations. He sued the district in federal court, same thing, takings, due process, equal protection, civil rights, all of that. And he, as far as I can tell, he flat out lost. Almost all of his claims were dismissed on what's called a 12B6 motion, which is a motion to dismiss because they were failure to state a claim. And his other arguments have been, I think all but one all of the takings claim, I think, have been dismissed. In the meantime, the district countersued for the enforcement, and that part's going forward. But I think the other parts are going to be appealed up to the District Court of Appeals. I'm very pleased with that result. And by the way, that's Deborah Trayvon was the attorney that kept Smith who won that lawsuit for the district up there. We do need to talk about the lawsuit that's been filed against the district, FOA versus Harris-Galveston Subsidence District. He also has now sued Mr. Turco, Mr. Dylan Jones, Brian Ladd as staffers. He included suing me and my law firm. He sued Natasha Martin, Bobby Selecki, and their law firm. No, Bobby Salat, S-A-L-E-H. He left the I off his name, so I'm not sure if that's a good suit or not. He also sued David Robinson and her managing partner and Bickerstaff. I'm saying the wrong name. I keep saying the whole name. It's Bickerstaff, yada, yada, yada. Yeah. And she's the one that has helped us have our Public Information Act requests, so he's unhappy with the result that he got for those PIA requests. And now he's also sued Alan and Kyle Sears. So We have a whole new,
That's why I made the motion. I've already been sued, no reason for any of you guys to be sued.
so, it's a suit, he's filed that suit pro se on his own behalf. Mr. Davis of Woodloch are not involved in that, which is why none of you had to recuse yourself from that vote. That lawsuit does not involve Woodloch at all. It's simply how he feels like he has been treated, told he couldn't practice in Texas without a license. And, we'll see where that goes to. The complicating factor is that because he sued so many different people and some board members in the district separately, we have gone to the TWA Risk Management Fund, who carries our insurance, to see how much that's going to be covered and whether or not they're going to provide a defense. As of right now, they have said they are going to provide a defense for Mike and the other employees. They haven't said anything yet about the two directors, because that's just now been presented to them, so they can review their policy and see whether or not that's covered. I believe they will cover the directors. In his lawsuit, he didn't.
Not, we have some better insurance.
In his lawsuit, he did not ask for money damages from the district. And so, because there's no risk of money damages, they have said they don't have a duty to indemnify, therefore there's no duty to defend. So they're not going to be defending the district. At some point, not yet, nobody's been served. None of the defendants have been served yet. He has been sending out emails asking us to accept service without having been served, and as far as I know, nobody has said yes to that. He needs to go pay to get the summons issued by the court, and then pay somebody to serve the summons and get all that done, and I'm happy to have him go do that. But the district is gonna have separate counsel, and so I have contacted Ms. Crago with Kim Smith. I have, let me get this to, there's a proposal from, Kim Smith. I've also contacted Deidre Coleman, who frequently handles federal lawsuits like this. I'll be happy to contact anybody else who can suggest that I contact or send in proposals for you. I believe at the next board meeting, assuming that we get served, we're going to have to vote on who we're going to hire as counsel to represent the district. I don't know what the other law firms are going to do. I'm not planning on hiring an attorney at this point. I think that, when you have a car accident, then the defendants quickly will turn on each other, right? The driver says it was the mechanic's fault, the mechanic says it was the manufacturer's fault, the manufacturer says it was the driver's fault. So they'll kind of have cases against each other, and they obviously can't have the same attorney. That's not the case here. There's not gonna be any conflict between any of these defendants, based on what he has said. So I think we can all kind of work under the same umbrella of the district's attorney. I do want to mention one other option. We have a unique provision in the two subsidence district statutes that allow you to ask the attorney general to represent the district anytime the district gets sued. So instead of hiring a private counsel, you may want to ask the attorney general to take it over. And Natasha, who's very familiar with several of the AG people that she works with routinely on statewide, state agency issues, has contacted them and said, knows who we have to contact to get that ball rolling. We would need to send them a copy of the summons when we get it. I would like to send them a copy of the suit since we have it. But it depends on what you all want to do, if you want to try and go to the AG or not. And that's, my only concern. We don't usually use the AG in any of our enforcement lawsuits, primarily because if they win a judgment, that money goes to the state of Texas, not to the subsidence district. And so we don't get recompense for any of the expenses we put into the enforcement lawsuit. So we used them one time on one enforcement lawsuit, those are these contracts. So that's why we don't really use them for those enforcement lawsuits. Also, we're kind of small fish in their big pond. Those types of things, I don't think we get the attention. This I think would be treated differently. But we have to remember that the Attorney General is an elected official, and when the Secretary of State was recently sued over whether or not primaries should be opened, the Attorney General chose not to defend the Secretary of State. So, the Attorney General can say, I think, can say, no, I don't want to defend you, but more importantly, it would give him the power to work out whatever settlement he wants to work out with Mr. Foley, and we would have virtually no control over what that settlement said. So that's, I think if we hire a private attorney, it's obviously more expensive, but it gives us more control over what happens to the lawsuit. So those are your options. And we can go to executive session to discuss anything else on that lawsuit if you want to. The last thing I mentioned, legislatively, things are just exploding every place. This whole data center issue has gotten people riled up. We have the far left anti-technology, anti-growth, pro-environment group, and the far right rural, not in my backyard group, agreeing and working together to try and kill data centers. It's a cycle of the whole. And right now, this district and none of the groundwater conservation districts in the state of Texas has any ability to say, no, you may not have a permit because we don't like how you're going to use the water. That's not something we can do. We can't say we like you, we get a permit, we don't like you, you don't get a permit. We have to treat everybody the same. And the conditions have to be based on how much water you're gonna produce, where it's gonna be produced from, how fast you're gonna produce it, what impact that's gonna have on subsidence. If we go beyond those issues, we've gone beyond our jurisdictional authority. So, we've been very careful not to treat people differently as we issue these permits and do the take enforcement. And we don't have the right to say, you're a data center, we don't want that in our neighborhood, so no, we can't have a permit. That's a one-way ticket to a lawsuit I really don't want to have to defend. If you make a shit like that, I will defend you. But it's gonna be a tough one. That's a tough one to win. So, it'll be interesting to see what the governor has said to put a hold on all data center development and issue permits by state agencies. That's almost probably gonna end up in lawsuits. Several different areas, small cities have adopted moratoriums against data centers. Several of them have already been sued. The ones that have been sued, I think, have immediately rescinded the order because they realized they didn't really have authority to do that. And they have more authority than the groundwater district. They have general development rules that they can allow. But you can't really just say, no, we don't want those businesses in our neighborhood. And so that has led to a lot of controversy and into a lot of discussion at the Capitol. I think there are going to be 50 or 60 groundwater related bills filed this session. And I just got a list from one of my clients of 15 different bills they would like to have filed on their behalf. As a couple of them are local to that district, and a couple of them will be statewide. And that's a very active district that's trying to get involved with the legislative matters. So it's going to be a very, very busy session. We're keeping a close eye on it as our legislative person, Kip Avery. I expect a lot of noise. I have no idea how much action. There'll be a lot of noise. I'll be happy to answer any questions.
So we're gonna take 8.1 into executive session. We're gonna take item 8.1 into executive session.
That's up to you all. I mean, we can, it just depends on whether you have any questions and have time.
We can certainly do that.
I think we ought to do that.
All right. So then, any other general questions before we move into executive session about the specific lawsuit that's filed? We would need a quorum to continue the meeting, yes.
They need a quorum.
We'll see, Michelle.
Right. Yeah, if we need to get to another meeting, that's fine.
I know the agreement, but we're doing that 11 first. Yeah.
I mean, I don't envision the discussion would be long.
Okay. Well, let's see where it goes and practice that out.
All right, then, time is 11:03 on Wednesday, August 8th. And the Board of Directors of the Harris-Galveston Subsidence District will now be in closed executive session to consult with an attorney on litigation, settlement offers,